Number 44, Altman versus 285 West 4th, LLC.
Good afternoon.
Thank you. Good afternoon, Counsel.
Good afternoon. May it please the Court, Jeffrey Turkel for the Appellant. This Court on two
Counsel, would you care to reserve any rebuttal time?
Oh, I'm sorry. Yes, 1 minute. Thank you. This Court on two prior occasions had the opportunity to address the meaning of what I describe in my brief as the second clause of the statute in question. In Gemrock v. Krugman, the last rent-stabilized rent was $920. The vacancy and longevity increases brought that rent to $1,247. And then there were individual apartment improvements beyond that. This Court in 2010 remanded the matter to the First Department to factually determine, and I'm quoting now, whether the landlord's expenditures for improvements were at least equal to the amount, in paren approximately $30,000, necessary to bring the rent above the luxury deregulation threshold. On remand, the Appellant Division found that the landlord's expenditures for improvements were sufficient to bring the legal rent for the unit above the luxury deregulation threshold. That finding, the Court of Appeals statement, the remand, the Appellant, Altman 1 cannot be reconciled with this Court's ruling in Gemrock. In the Roberts case of 2009, this Court was recounting the history of the luxury deregulation statute, and in particular what happened in 1997, the Rent Regulation Reform Act of 1997. And the Court said about that statute, which added the language in the clause that we're all here today, said the legislature subsequently expanded the scope of luxury decontrol by allowing post-vacancy improvements to count toward the $2,000 per month rent threshold. That is correct. That is a correct statement of the law in my impression. Altman 1 cannot possibly be reconciled with that statement. The current statute talks about decontrol as long as the apartment is or becomes vacant with a rent of $2,000 or more per month.
When you say the current, you don't mean the 2015 amendment?
As it stands right now, the language in the second clause has not changed substantively since 1997. So as things stand now, it says that deregulation occurs when there is a vacancy between 1997 and 2011, and the apartment with a rent of $2,000 or more per month.
So if he never physically left, why is there a vacancy? Is there some definition in the law that you can point to for vacancy?
Yes, I can. Section 2520.6G of the Rent Stabilization Code defines a vacancy lease as the first lease or rental agreement in a housing accommodation that is entered into between a tenant and an owner. This was, under that definition, unquestionably a vacancy lease. Mr. Altman was a subtenant of the former tenant, Mr. Ryder. He was not a family member of Mr. Ryder. He was not a non-traditional family member. He was not named in the lease, and he had no privity with the landlord. This is a vacancy. No court in this case has found to the contrary. And the case law, I cite the tenant case and I cite the...
Does the title of the lease define whether or not there's a vacancy within the meaning of the law?
No, Your Honor.
And you could call it something else.
Well,
You're not defining vacancy, and that is my problem with that.
It's the closest I can find to a definition of vacancy.
That's what I wanted. This is as good as it gets for you in that argument, right?
Yes,
There's
but
not
there is
somewhere else I can look for this definition.
Well, what the case law says is if the tenant of record, as here, vacates, and the subtenant in possession then signs a lease, that is a vacancy for purposes of luxury deregulation. There is case law to that. There is no countervailing case law.
Let me just take it back a step. Are you arguing that Roberts, we're talking about Roberts versus Tishman Speyer, right? That supports your position?
Yes, because the court, that case was about J51. In the course of
Right.
recounting the history of the luxury deregulation statute, the court had occasion to comment on the 1997 New York State legislature, their act, the Rent Regulation Reform Act of 1997. And the court described that as the legislature expanding the scope of luxury deregulation by allowing post-vacancy improvements to count toward the $2,000 per month rent threshold. What that
Well,
is
I'm looking at the First Department opinion, and the First Department opinion says, talking about high rent or the luxury deregulation, which is what we're talking about here, and it says, in specifically talking about 26-5041, is or the tenant vacates the apartment and the legal rent plus vacancy increases, which is a 20% allowances, and increases permitted for the landlords is $2,000 or more, so the vacancy increase allowed there. In the Court of Appeals, we said, if the legislature expanded the scope of luxury to control by lowering the income threshold for defining high-income households to 175, and then emphasizing and allowing post-vacancy improvements to count toward the more than $2,000 per month rent threshold. And here, I understand, I'm from Buffalo. We don't have the rent stabilization law. So this is always an adventure when I read these cases. I always feel I learn a lot, but it still seems to me that here we're talking about one of two things, either individual apartment improvements or the post-vacancy rate increase of the 20%. And this case doesn't seem to say what you're saying it says.
Well, Roberts, it's true, talks about post-vacancy improvements, but the case that I believe is much more directly on point, because again, Roberts was about J51, and the ultimate ruling was that if there was a J51...
But you would agree with me that that language does not support your point.
I do believe that it does support my point because in Altman 1, the court said no post-vacancy improvements, whether they're vacancy increases or individual apartment improvements. So to the extent that they said that the rent had to be $2,000 at the time...
Altman 1, what the Court of Appeals says allowing post-vacancy improvements count toward the $2,000 per month rent threshold.
Yes, I understand that, Your Honor.
Okay.
Certainly to the extent that this court opined in that case that post-vacancy improvements could be used, that's contrary to Altman. Altman said it had to be $2,000 at the time. I think the case that's more relevant is the Gemrock v. Crouppen case, where this was absolutely at issue. That was a deregulation case. And the court said, you have the $920 rent, you have the longevity and vacancy increases that bring you up to $1,247. We're sending it back to the appellate division to see whether the individual apartment improvements, when added to the original rent and the longevity and vacancy increases, get you over the $2,000 threshold. That directive would not make any sense if Altman were correct. To date, we haven't talked about the language of the statute, which I'd like to ask the court to look at, as well as its legislative history. What the second clause says, as amended in 1997, is that the deregulation or housing accommodation is not defined as an apartment that became vacant between 1997 and 2011 with a rent of $2,000 or more per month. I would not claim that the word with is the most exacting or precise word. Because the word with is somewhat vague and allows for some degree of interpretation, then I think we go to the legislative history, because the cardinal rule of statutory interpretation is that the court is supposed to further the will of the legislature. What's striking about this case is how clear the legislative history is. Often legislative
The
history...
amendment was for the very purpose that you're talking about.
I can't say it any better than that, Your Honor. Sometimes reading legislative history is like reading tea leaves. Here, it is strikingly clear. I mean, I don't see how it could be more clear. The Senate introducer's memo says decontrol shall be allowed at any time the vacant apartment has a maximum rent of $2,000 or more. The bill eliminates restrictions imposed by the City Council which currently prevent vacancy bonuses and owner improvements, both, from being considered in reaching the $2,000 threshold. The governor, in his approval memorandum, said the same thing. I won't read the language. Even more clear is that, you know, there was kind of a revolution and then a counter-revolution. In 1997, the City Council stepped in and said, no, we absolutely have to have a rent of $2,000 at the time the prior tenant vacates. And they wrote it into the statute in very, very, very exacting language. And then 2 months later, the legislature said, no, this is not going to stand. We're not going to do that. I think that if we look at the Court of Appeals history, the legislative history and the language of the statute, I think Altman 1 has to be overturned.
Counsel, do you want to take a moment and cover all bases and address the rent calculation?
Altman 2, you mean?
Yeah,
Well, Altman 2 is only relevant if Altman 1
correct.
is affirmed. I think that Altman 2 is just unduly and unusually punitive. I think that we can all agree that the state of the law prior to Altman 1, there's a lot of cases, there's a DHCR regulation that was promulgated in 2000, renumbered in 2014, that says take the old rent, add the vacancy, add the individual apartment improvements. If it's over 2,000, it's deregulated. If it's under 2,000, it's not deregulated. All the landlord did in this particular case is follow the law. And in fact, we know that because annexed to the deregulated lease at page 50 of the record, we have a notice that was provided pursuant to the statute, which says to the tenant, this is a deregulated lease, and it is deregulated because, and the landlord checked off, the old rent was $1,829, and with the vacancy increase and any other allowable increases, the rent is now over $2,000. Therefore, it is deregulated. And the tenant, Mr. Altman, signed that at the bottom, received. I don't think there's any question that the landlord's only crime here was following the law at the time. Thank you.
Counsel?
Thank you, Your Honor, and if it pleases the court, my name is Lawrence Rader, and I represent the respondent, Richard Altman. Two unanimous panels of the appellate division were crystal clear in interpreting a statutory provision which had not come before them
What was the
before.
purpose of adding the second provision? What was the purpose?
Pardon me, Your Honor?
What was the purpose of adding the second clause to this statute?
It's an interesting question, Your Honor,
Well,
but
there has to be a purpose, right?
both sides would and have conceded, as have the various briefs that have been submitted, that this statute has been put together through a variety of amendments and additions, and it does appear as though the second clause was inartfully added to the first clause. However,
But doesn't the legislative history indicate what the purpose was? So are you just saying that they didn't do what they intended to do?
not in this case. I'm not saying that at all, Your Honor.
So what is your
What
argument?
the second provision said is, in fact, consistent with the first provision in that it said is or becomes vacant with a rent of $2,000. And neither of those things happened here.
But if it didn't change the first provision, what did it do? And
It-
why does the legislative history tell us something different?
The interesting thing about the legislative history, as I have looked into it, is that this law was actually allowed to expire for a few minutes at midnight while the Democrats and Republicans fought it out over whether this would go in the way this is. Now, what you've got is the landlords hanging really their entire case on the governor's memorandum. But the governor lost that battle, and the legislature chose its language carefully. Now, if the word "or" is meant to suggest that it meant something different, then they easily could have said so. They negotiated with one another, as a legislature does, and they voted this statute into place, and even the second sentence supports Altman's position. What I find interesting about the landlord's position is that it ignores years of precedent from this court, including in cases which concern rent stabilization and deregulation, that if the landlords aren't happy, they can go back to the legislature. There's a tremendous irony here in the Landlords Council bringing up
But doesn't
Roberts.
Gemrock support their position?
Gemrock doesn't support their position.
Why not? Why
Because,
not?
because like all of their cases, and again, Your Honor, most of their argument is the word "or" and the government's memorandum. All of their cases are about improvements and and improvements did not take place in this case. So as we say in our brief, the landlords are arguing many different things in many different cases, but the case before this court
But in
had no
Gemrock, don't you
improvements.
already have the vacancy allowance being added?
There was a vacancy allowance, but it didn't bring it over $2,000. So again,
Right, and so then that was the point of Gemrock sending it back to see if indeed the improvements might bring it over 2,000.
and the appellate division, when it got it back, said that it brings it over 2,000, but did not definitively determine that that would cause the statute to be read as the appellate division very clearly determined in Altman 1.
Would it have been over 2,000 without the vacancy allowance?
No, without the vacancy
Gemrock.
allowance? I don't believe it would have been over $2,000 without the vacancy or
What
without
would
the
have been the
improvements.
point of the remand?
The point of the remand was to consider all things considered, all things that were part of the record, including improvements, as is all of these cases which the landlord points to, as are all of the cases which the landlord points to, which supposedly in the last few months represent the appellate division reversing itself, despite the fact that the appellate division never once says, today we reverse ourselves. They're all about improvements or different issues. One is about an apartment which had previously
Is
been
there
rent controlled.
any place in a statute, a regulation, or in a case law that you can point me to that defines a vacancy as in the actual physical departure? No one is in physical possession of the apartment?
Well, we cited the dictionary because when something is vacant, it has nothing and nobody in it. And as Your Honor asked counsel, and I don't believe there was much of an answer, it appears clear that there is not a vacancy in these circumstances. Jazilek does in fact
Well,
say
it could be
exactly
vacant
that.
because you don't have a lawful tenant in possession, right?
There's no tenant in
I mean,
possession.
I
The apartment
could
has
be a
nobody in it.
lawful, correct, but I don't think you're arguing your client was a trespasser at the time they were in the apartment between the surrender date and the first day of the new lease, correct?
No, my client was a
Okay.
subtenant.
All right. So, but let's say I'm renting an apartment that happens to be regulated, stabilized apartment, and I'm on vacation. You're not arguing that the apartment is vacant in the way you're arguing it here, simply because I'm on vacation and not in physical possession, correct?
No, it is not
Right? I'm
vacant.
still a tenant. I still have rights over this apartment, correct? So
You're on
the,
vacation? You vacated your apartment for a couple of weeks to go on vacation?
right,
No,
you're not arguing that's vacating, that the apartment is vacant, right?
I'm
In
not
that
ar-
sense, right?
I'm not arguing that,
I've still
no.
got rights over possession and so forth, right?
No, nor am I arguing, or
Correct.
would I argue, or I
Correct.
think would
Correct.
even the landlord argue,
So, when the
that that
prime
would create
tenant
a...
here, yes, so when the prime tenant here is properly still in tenancy, but then surrenders the tenancy, isn't the landlord the one who has rights of this physical possession?
Not in this case, because they were done simultaneously, and not in the Jazilek case. And no, I don't believe that's the
But
case.
doesn't the new lease start the next day, or am I wrong?
No, I think
Is
it
there
started
overlap?
simul-
Do
I
they
think-
start at the
I
exact
think they
same
started
day?
simultaneously.
They're both tenants the same day.
They drew an agreement that said one surrenders and one gets a lease. But, Your Honor, I would also point out that vacancy is not the only threshold by which Altman 1 is correct. Clearly, there is the issue of whether they were entitled to the increase and to use that increase in order to deregulate the apartment. So while we argue vacancy, and I think it's an interesting semantic point, whether that word kicks in at the moment that somebody moves out, or instead at the moment that a lease changes hands, the court can very easily find, as the appellate division did, that the
Vacancy
$2,000
increase.
threshold is still not met.
All right, let's go back a second, because I was pushing counsel on Roberts, and, he made some good points that it supported the defendant's position, and the language that I quoted to him talked about the tenant, the tenant vacates the apartment and the legal rent plus vacancy increases, and increases permitted, the landlord is $2,000 or more. Here, the vacancy rent increase, if applied, would take you over the $2,000 threshold, right? Yes.
Yes.
Yeah, okay. So that being the case, and this being the language in Roberts that they're relying on, why is that incorrect? Why doesn't it apply? What am I missing?
Roberts did not say that that would therefore entitle the landlord to deregulation. Roberts sent the case back with respect to a novel situation with J51, followed by a massive improvement project.
No, I understand it was a J51 case, and we're not talking about that particular issue. But it did talk about the scope of the RSL and whether the legally regulated rent is $2,000 or more and how you get there. And it was really the first time the Court of Appeals thoroughly analyzed it, so it's important to us.
And I think the court got it right, that it would kick it over the $2,000, but I still believe that only the next tenant after the tenant who kicked it over $2,000 would be the one who'd get a destabilized lease. And that was cleared up in Altman 1, and I believe this court is, in affirming Altman 1, would not be doing anything inconsistent with Roberts.
So what do you do with the Park case that came after in the appellate division?
Park's an interesting case, Your Honor. First of all, it involved a rent-controlled lease which converted into a rent-stabilized lease. So it had a different standard for increases. It also was an apartment occupied by a famous actress who was...
I'm familiar with the facts.
What's interesting about that is that we frequently hear about rent-controlled tenants who are the least people in the world who should have rent-controlled apartments. This, I believe, 6-bedroom, 8-bathroom apartment, which by any measure qualifies as a luxury apartment, is what the legislature intended, I believe, when the legislature passed laws to protect tenants. But every other apartment which we cite, or virtually every other apartment which we cite, goes to an entirely different thing, which is that this statute protects affordable housing and tenants. And a $2,000 apartment in the city of New York, or today a $2,700 apartment in the city of New York, is by no means a luxury apartment, and as has been argued in the various briefs, gentrification and removal from neighborhoods of people's housing is what's
But I wanna
affected.
get to
One other thing, Your Honor,
the specific language in Park, which I think seems to imply that if you put aside the, vacancy, the post-vacancy improvements, that it still would have been entitled to an increase because of the vacancy allowance.
I don't believe Park says that, Your Honor. I think it very specifically speaks to the improvements, which were massive improvements, which turned it into an incredibly luxury-style apartment.
The 2005 vacancy allowance alone brought the rent for the apartment to $2322.72, an amount that was over the threshold.
Which is true, but that does not again state whether they could have destabilized on the basis of that. Just as Mr. Altman's apartment with 20% added brought it above $2,000. This is the issue which the appellate division decided and which is before this court. The improvements in Park change things quite a bit, and they are clearly provided for in the decision, but I would still ask this court to consider why would the appellate division overturn its own decision without ever mentioning it.
Thank you, counsel. Counsel?
I'll waive rebuttal unless the court has any questions.
Thank you.